all for coming. I really appreciate it. A lot of new faces in the room, so I'm just going to introduce myself super briefly. My name is Shawn Straub, and I own SPHR Partners. I started it about a year and a half ago, and before that, I was in the corporate world for 20 years. I worked as the head of HR for a variety of different organizations, from healthcare through retail, and I worked for global organizations as well as in the US. So I do have a wide breadth of knowledge as far as different types of organizations and different types of employees. And my thing that I love doing best is helping companies mitigate their risk through understanding employment law. So this is actually, of all the presentations that I do, this is by far my favorite. Okay, so employment laws. So the first thing that we talk about with employment laws is protected classes. How many people have heard of protected classes? Okay, protected classes is basically something that makes you different than the person sitting next to you. And in the US, there are lots of laws that protect these types of protected classes. There are federal laws, and then there are state laws. And so when we talk about federal and state laws, there are two different categories. So this side has our federal protected classes, and then North Carolina has its own set of protected classes. And you'll notice that there is a lot of overlap between them, but there are some significant differences. So when we talk about race, color, those are pretty self-explanatory, but we get down to religion and religion or creed. So in the state of North Carolina, you are protected for the type of religion that you have. Federally, you are protected for not only your religion, but your creed. And a creed is simply a sincerely held religious belief. So, how many people have heard of the Great Spaghetti Monster? Okay, at least one. So, the Great Spaghetti Monster is back up in the state of Vermont, there is a woman that she went to the state and she wanted to make sure that she had a colander on her head for her driver's license picture because she believed in the Great Spaghetti Monster and she wanted to show reverence to the Great Spaghetti Monster at all times, including in her driver's license picture. And the state of Vermont was like, are you kidding me? What are you saying? And under the creed portion of it, it was a sincerely held religious belief for her, and she fought, and she has won twice so far, and she does have a colander on her head in her driver's license photo. A little more close to home is about dress code. So about 10 years ago, a woman sued Costco. So Costco has a pretty strict dress code that says that you can't have any facial piercings. So no nose piercings, no eyebrow piercings. This woman had an eyebrow piercing. And Costco said, you're gonna need to take out that eyebrow piercing. And she was like, no, I belong to the Church of Body Modification. And as part of that, I'm not gonna take out any of my piercings. And Costco kind of laughed at her and was like, yeah, you're gonna need to go home, take out that piercing, and when you're ready to come back to work, we'd be happy to have you. And she was basically like, yeah, instead I'm just gonna go to the attorney's office. So she went to an attorney and she claimed that her sincerely held religious belief was the Church of Body Modification, and that as such, she should be allowed to have whatever piercings or modifications that she needs. And in the end, she won that case. And the reason why she won that case is because Costco didn't believe her. Costco didn't engage in any kind of conversation with her about this Church of Body Modification. So when someone comes to you and talks to you about their sincerely held religious belief, while in the state of North Carolina, we don't have a protection for it, federally, there is a protection for it. And it is something that we want to make sure that we are paying attention to, okay? The next one is national origin and ancestry. Okay, so national origin means where you personally came from. So state of North Carolina recognizes that. Federally, we recognize that. Federally, there's also protection for ancestry, and that means anybody going back in your family. So it doesn't necessarily mean where you personally came from, but it could mean anything going back in time. So if your ancestors were Irish and you feel like people are discriminating against you because your ancestors came from Ireland, federally you could be protected under that. Sex, your physical sex. Age. So this one I think is really interesting because it's, like many of these, a rather old law. So according to the federal government, can anyone guess how old they think old is? Yes, you knew that one. Yes, age 40. Once you hit 40, you are officially old from the government's perspective. And that means that you are protected as well. So you are protected from discrimination. There is a current lawsuit about age discrimination from the, oh my gosh, I forgot the name of it. One of the local steakhouses that we have that's also a national brand. And there is a lawsuit saying that they are only hiring people who are young for front of house, and anyone who is over 40 is being hired for back of house. It's a current class action lawsuit that they're currently accepting applications for, and this could be worth millions of dollars to the people because it turns out it's true. The people who are working front of house are younger, and the people who are working back of house are people who are 40 or older. Physical and mental disability. So that's protected both federally and state. Genetic information. This is one of my favorite ones because I think, when you first hear genetic information, how as an employer do I have anyone's genetic information unless I'm working in healthcare? Actually, it's really easy to have someone's genetic information. So you have an employee and they tell you, my dad just had a heart attack, or my dad was just diagnosed with Alzheimer's. And now you know that, oh, heart disease may run in their family, Alzheimer's may run in their family, and this person starts forgetting things, or you're starting to get worried about this person, so you start taking things away from them and you start treating them differently. You're treating them differently based on genetic information that you know. Citizenship. So citizenship specifically means, are you a US citizen? Did you immigrate here? There's an entire law about that. The Immigration Reform and Control Act, those I-9s. How many people heard of I-9s? Hopefully everybody in the room. So this says that you can't discriminate against somebody if they're legally able to work in the United States. Military status. So this is whether they're active or non-active, a veteran, on reserve. There's an entire law about this as well. It's called USERRA, Uniform Service Employment and Reemployment Act. I think I missed an R in there. But USERRA protects people who are in the military or who are reservists or who are veterans. And then in the state of North Carolina, we have some extra ones in there. We also protect against people with AIDS and HIV. And sickle cell and the hemoglobin C trait. And then one of the unique laws to North Carolina that I think will get incredibly interesting as we move forward and marijuana becomes legal across the US is that we have a law that specifically says you cannot discriminate against someone for the lawful use of a lawful product when they're not at work. So right now we can think about that as alcohol, right? So someone goes to the bar the night before, they drink, we can't do anything about that. Or smoking, we can't say that you can't smoke. A lot of health insurance companies are trying to say that you get a better rate if you don't smoke, but we can't say we're not going to insure you if you don't smoke because it's a lawful product. So as we move forward with marijuana legalization, this will be a very interesting law to watch in North Carolina because if somebody is smoking out of work or utilizing a product that has THC in it outside of work and it's legal, can we truly hold them responsible if we do a drug screen and it comes up on their drug screen? And there are actually lots of states right now where they're not even testing for marijuana anymore in drug screens. It's just completely off the table because it is something that is becoming so complicated and it stays in your system for such a long period of time, even if you're not physically intoxicated by it. Okay, does anyone have any questions on any of that? So why did I tell you all of that? I told you all of these things because it's incredibly important that we don't treat people differently based on any of these protected classes. And there are two really specific ways where we need to be careful about it. The first one is harassment. So there are two basic types of harassment. There is quid pro quo, this for that, and hostile work environment. When we think quid pro quo, you know that show Mad Men, or you've heard of the show Mad Men. You have the executive with the secretary. That's quid pro quo. You do this for me, and you get to keep your job, or you get a raise, or a better review. And then hostile work environment is a little more complicated in that it's usually not just one single incident. It's something that's pervasive and something that's happening over a period of time. So quid pro quo is generally committed by someone who's in a position of power to somebody else. This is, if you think back to like the 1980s sex scandals when women started, working out of the home, and if, for those of you who are as old as me, that doesn't seem like that long ago, but it is. And this was really prevalent back then. These types of claims have been on the decline, whereas hostile work environment has been on the increase. And it's because I think people have become more aware that this is something we shouldn't be doing, whereas hostile work environment is a little more ethereal and it's harder to pinpoint. So hostile work environment is any kind of unwelcome conduct from supervisors, coworkers, contractors, people who come into the building, people who are delivering your soda, anything that can make an unwelcome environment for the person who is there. And it needs to be something that's pervasive. It needs to be something that happens on a regular basis. And in both of these instances, it needs to be something that happens because of one of these protected classes. Okay, so one of the big things that comes up often when people are talking about this is someone's weight. Okay, weight is currently not a protected class. It may be in the future, but right now it is not. So when you're talking about a hostile work environment or you're talking about harassment, and you say, well, this person keeps making fun of me because of my weight. It's not okay. It's not something that we want to have in our work environment, but it's also not illegal right now. So as business owners, it's really important to know the difference between behavior that's definitely not okay and behavior that's not okay and also illegal. So when we think about harassment, we think about discrimination, we want to make sure that we remember these protected classes, which is why we talked about it the first time. Okay. The other part is discrimination, and I think this is a lot easier for everybody to sort of conceptualize. Discrimination sounds easy. We're discriminating against somebody based on one of those protected classes, and discrimination takes lots of different forms. But it is the treatment or the consideration or making a distinction in favor or against a person based on one of those protected classes. Discrimination can happen from the time you post a job advertisement all the way through termination. And someone can file a discrimination claim against you from the time that they apply for your job all the way through termination. So it's incredibly important that we make sure that in all cases, we're never making any type of judgment based on one of those protected classes. So I just yesterday heard a story about a fitness studio, and they're currently looking for people to work at their front desk. And they had all these applicants apply, so they went to Facebook and they looked at the applicants' Facebook pages before they decided if they were going to bring people in for an interview. And they sorted people by, this person looks like they have a fitness lifestyle versus this person looks like they do not have a fitness lifestyle. I highly recommend against that. There are lots and lots of reasons why that's absolutely not okay. So by making those judgments and making those decisions, obviously you're not just making them based on the fact that this person was like lifting weights in their profile picture versus they weren't lifting weights on their profile picture. You're looking for other things when you're looking at those Facebook posts. And so what's really important is to make sure that you're judging people based on their skill set and not based on the way that they look or any of those other protected classes that are up there. Does that make sense? Okay. So discrimination can be everything from stating or suggesting preferred candidates in a job advertisement. And if you think that doesn't happen, this literally happened 3 weeks ago to me. I was at a networking group and someone said, oh, I'm trying to hire a secretary. And someone else in the networking group said, oh, do you want a man or a woman? And I was like, what are you talking about? And he's like, oh yeah, well, you know, do you want to hire a man or a woman? Like, who should I refer to you? And it's like, no, you can't do that. Like, you absolutely can only make decisions based on the person's skills that they bring to the job and nothing else. So when you're talking about stating or suggesting preferred candidates in job advertisement, back in the olden days, and by that I mean like the 80s and 90s, you could write like, you know, 20-year-old female needed for a front desk position at busy law office, and that would have been totally fine. But it is absolutely not okay now. Now we base all of our job descriptions and all of our hiring decisions based on skills and not on any protected class. Excluding any potentially qualified employees during recruitment. Someone comes and they are 4 months pregnant, and you decide, should I be hiring them? Should I not be hiring them based on the fact that they're pregnant? Pregnancy is also covered under a protected class. It's under the sex part of the protected class. You can't discriminate based on that either. Denying certain employees compensation or benefits, that one's pretty easy. Paying equally qualified employees in the same position substantially different salaries. That is absolutely not acceptable, and this is something that we see, that we have seen more recently. Men and women in the same position, women making substantially less than men. This is something that's in the national news. This is something that's still happening today, even though we have things like the EPA, which is the Equal Pay Act, ensuring that people are not paid differently. People are still being paid differently. So it's really important that when you look at your compensation, that you're looking at everybody as an individual and not based on the sex of that individual. And then issuing promotions or layoffs for any kind of non-business reason. You have brown hair, I like you better, so I'm gonna promote you instead of this person over here. There are two different kinds of discrimination, and the first one is the easy one, the one that we think about often, and that's disparate treatment. And that's really when you're treating someone differently or your managers are treating somebody differently based on one of those protected classes. The second one can happen when you may not even know that it's happening, and that one is called disparate impact. And that's when you have a process or a rule or a policy in place and you're actually impacting an entire protected class and you may not know about it. So one of the ways that I've seen this happen often is when we say that we need to have, that you need to be able to speak English to, apply for this job or to have this job. So I worked for a company where we actually had several retail stores that were in areas of the country where the customers didn't actually speak English. Most of our customers spoke a different language. So for us to put into a job advertisement, you need to speak English or you need to speak Spanish, we were really excluding an entire group of people. So it's really important that you're very careful when you're writing them, that you need to be able to communicate with management and customers. That's what I always tell my clients, that's how we're going to describe it, because we want to make sure that we're not discriminating against any group of people and that everybody has an equal chance to apply for the job. Okay. Any questions on any of that? Okay. Oh, there's a slide. Okay, hold on one second. So it's not up here. I'm just going to talk about it. There's a slide missing. It's about retaliation. So retaliation is the other form that you need to really be careful about. And retaliation is when you act out against somebody based on the fact that they have complained about harassment or discrimination, or they've made a claim against the company, they've participated in an investigation. Basically, they've done something and now you're not happy that they did it, so you're gonna retaliate against them. And retaliation is the biggest form of lawsuit that's currently happening in the US because it's tacked on to all the different lawsuits. So someone complains to you that they're being discriminated, they go through the process, you try to solve it, and now they feel like, or their lawyer feels like, they're being treated differently because they went through the process, so now you're also tagged with a retaliation claim. So it's really important to make sure that when someone complains or when somebody participates in an investigation or tells you that there's something wrong with the company, a whistleblower claim, that they're still treated exactly the same as you move forward. Okay, now I'm gonna talk to you about posters. How many people, and I brought this because I literally just got it yesterday, how many people have gotten things like this in the mail that look super official, that say you need to put up employment law posters and it's gonna cost you, in this case, $89.50. Okay, how many people were scared by this? A couple, okay. So while it is true that yes, you 100% need employment law posters, if the government wants you to post something, they're going to give it to you for free. So every employment law poster that you need to post, and North Carolina has an employment law poster, and then there are several federal law posters that you do need to have. They're all available for free on the internet. And North Carolina actually has one of the best employer-friendly employment law poster searches that I have ever seen. You go to their website, their government website, and they ask you a whole bunch of questions about your business, how many people you have, what kind of industry you have, and then it just comes up with a whole list with links to the actual poster that you can print out. North Carolina will mail their state poster to you, yep, for free. The federal posters you can print out right from the website. And for my clients, you know, sometimes I print them, I laminate them for them, the whole thing through Office Depot's $14, as opposed to $89. So when you get these, don't be scared. Yes, you definitely need employment law posters, but these people are just trying to make money off of you. And anytime the government wants you to print something or post something, it is 100% free, I promise. And they'll then tell you when you need to change them as well, because these companies also offer that. Like, you know, it's gonna change all the time. It never is gonna change, I promise you. Like, maybe when the FLSA changes in January, we're gonna change one of the posters. But in general, like, those posters have been around for a long time. Did you have a question?
Yeah. Real quick question. If you're transitioning employees to remote work environments,
yeah.
What's the requirement there? I mean, do you post them virtually, or what do you do?
So that is a great question, and a question that hasn't really been addressed. And what I advise my clients to do is have some type of virtual, like a folder that says these are the employment law posters. Yeah, and if you have, like I have one of my clients, they're like a construction company, so they don't have like a central location, they have trucks. So they literally have them printed out in a binder in the trucks. So I think to veer on the safe side, let's make sure that employees have access to them. But I think this is a new and evolving area, and the government is pretty behind in their recommendations. So just have it virtually for them, so that way they have access to it. Mm-hmm. Any other poster questions? Okay, now Caitlin stepped out, and this was her slide that she asked for, so hopefully she'll come back. So one of the things that I'm often asked is, I only have one employee, this stuff doesn't apply to me, right? Or I have 2 employees, or I heard that FMLA kicks in at 50, so nothing really applies to me. That is 100% not true. There are lots and lots of laws that apply to you, even if you only have 1 employee. And this very first line is all the laws that apply to you, even if you only have 1 employee. It applies to every employer in the US. And the first, so I know I just put some letters up there, so I'm just gonna go through them. So EPA is the Equal Pay Act that I was talking about, so everyone needs to be paid the same. FLSA, we're gonna talk about that, so it's the Fair Labor Standards Act. That's if someone's exempt or non-exempt, how many hours they can work. OSHA, everybody's heard of OSHA before. ERICA, that's the Immigration Reform and Control Act, so that's saying that you have to fill out those I-9s. USERRA, that's the Uniform Service Employment and Reemployment Act, and that one is for people who are in the military. ERISA has to do with benefits for retirement, and then the Polygraph Act is a federal law that has its own poster that says that you can't use polygraphs for your employees unless there's some very specific reasons why. So that's for everybody. Then we move down if you have 15 or more employees. And there we have GINA, that's the genetic one that I talked about. PDA is the Pregnancy Discrimination Act. Title VII, that's the one that you probably have all heard of before, race, sex, gender. And ADA, the Americans with Disabilities Act. Now, I like to tell people this as well. Just because you don't have 15 employees doesn't mean we shouldn't be following all of these laws. It doesn't mean that it's okay to discriminate against somebody based on their race, their sex, their gender. Everybody should really be concentrating on the fact that everyone should be treated equally and fairly, regardless of how many employees that you have. If you have 20 or more employees, you fall into COBRA. COBRA is the, I'm not gonna go through it, but it basically, if you leave your job, they have to continue your health insurance. So for those of you might have been on COBRA before. And ADEA is the Age Discrimination and Employment Act, where the government thinks 40-year-olds are old. 50 or more employees, and we get into FMLA. That's the Family Medical Leave Act, and that gives people 12 weeks of protected time off of work. It doesn't say anything about how they're paid. It just means that they can be out of work for up to 12 weeks for their own illness, for the illness of a family member, or for pregnancy. There's also a whole section in there about military leave that was recently added, not just for the person in the military, but for their immediate family and caregiver in case they come back injured, or we have what's called an extingency leave, where the person's getting ready to go out to be on active duty, and so the immediate family member can take time off of work to prepare for that person to leave, okay? If you have 50 or more employees and you fall into FMLA, it's really important that you have somebody who can help you walk through that process, because FMLA is really tricky and there's a lot of paperwork that goes along with it, and it's incredibly important that you protect yourself and your employees by following that process really specifically. 100 or more employees, you get the WARN Act. The WARN Act is if you're going to lay people off, you need to give them advance notice that you're going to lay them off, and it has a couple other things put in there. And then you also will need to fill out an EEO-1 report, which is due every September. And the EEO-1 report, I don't know if you've seen in the news, it had some past couple years has been a little tricky. But basically you're reporting to the government the people who work for you, and it's like a census. Like you're reporting things like their race, their age, their gender, their job title, things along those lines. So it's important to make sure that you're doing that every September as well. Okay, any questions on that? Okay, now going back to posters, as you can imagine. So if you have even just one employee, you're gonna want posters on that first line. As it goes down, you'll have more posters that you need to make sure that your employees are aware of. But I'm telling you, that North Carolina government site, awesome. And you can certainly enter in the number of employees, and it's gonna give you exactly what you need. Yes, ma'am.
So will that give you, the North Carolina site will also give you the federal
Yes.
posters too? Everything?
Mm-hmm. Yeah.
Okay.
Yeah. Yep. Okay, so does anyone have questions on that one? Okay, where do you guys fall? We'll start at the bottom. Anyone have 100 or more employees? 50? 20? 15? 15, okay. And then everyone else falls into the other ones. Okay. So it's really important that we make sure that we're complying with where we are. Yes?
So a question on what defines employee.
Okay.
So I had a couple of people who were contractors.
Yeah.
And then recently I just signed them on as members of the LLC.
Okay.
Are they employees as owners, or does it come down to how they're getting paid? How does that work?
That is a tricky question. And it depends on what title you gave them in the LLC. So an owner can be exempt in some instances and non-exempt from the laws in other instances. So it's important to really look at that, and an attorney might actually need to really look at what on how you titled them in the document. But the easier part of that, if they're a contractor, they don't count as an employee. Any other questions on that? Okay. So here are some common federal laws that we talked about a little bit. And I know you guys want to talk about FLSA, so we're going to skip to that one. Okay, so the Fair Labor Standards Act. So the Fair Labor Standards Act is this really inclusive act that was made all the way back in 1938. And when it was made back in 1938, it was created because the people who were these factory owners were basically treating their employees as indentured servants. So there was nothing that said how many hours they could work, what they needed to be paid, how old they could be. So they had a lot of kids working for them as well. And the Fair Labor Standards Act was put in place during the Industrial Revolution to make sure that employees were being treated fairly. So it was sort of like the beginning of being in a union. The government was putting some rules into place to say, you can only work this many hours. If you're working more than that, you need to work overtime. You have to be paying people at least this much money, and they have to be a certain age to be able to work. And if they're younger than that, there are some restrictions around the time that they can work. And so those parts of the act are still in place. We've certainly changed a little bit, some of it as far as like how much money people get, but some of it is really identical to what it was back in 1938. So it keeps track of things like minimum wage, overtime pay. It also is about record keeping. It's also telling you how long you need to keep your payroll records and that you need to keep payroll records. So you need to have some method of collecting your employees' hours, and then you need to keep that information on site in case you're audited at some point. So it's really important that you have that information as well. So anyone who is a non-exempt worker is entitled to at least minimum wage, which was set way back in 2009 at $7.25 an hour. Now there are some states who have their own minimum wage. Well, every state has their own minimum wage, but some states go above and beyond the federal minimum wage. North Carolina is not one of them. North Carolina, our minimum wage is also $7.25 an hour, and it would appear that we would continue along that path. There have been some laws that are presented, but they have not gone anywhere. Overtime pay is also set by this, and overtime pay is basically that you have to pay at least 1.5 times normal pay for any hours over 40 hours. So this is where keeping those time records is incredibly important to make sure that if your employee is working over 40 hours, that you're paying them for that time. Now, sometimes we may not want them to work over 40 hours because we don't want to pay them for their overtime. Those are two separate things. We can go down a disciplinary path and tell them that it's not acceptable for them to work more than 40 hours, but if they've done it, we still need to pay them by law, okay? So if somebody's worked the hours, they have to be paid for the hours that they work, regardless of if you approved it or not. That's a separate conversation for them. We just talked about that. So when we're talking about FLSA, we talk about that, their hours worked, we talk about record keeping, and we talk about child labor. So in the state of North Carolina, and I don't know if everybody can see this one, but in the state of North Carolina, these are the child labor laws. So now that school is back in session, this may not be as important to everybody, but during the summer, this was certainly something that most people were interested in. But if someone is under the age of 14, they may not work at all in the state of North Carolina, regardless of whether it is summer break or not. 14 and 15-year-olds, when school is in session, they can work 3 hours a day between the hours of 7 a.m. and 7 p.m. for a total of 18 hours a week. If school is out, they can work 8 hours a day between 7 a.m. and 9 p.m. for up to 40 hours a week, but they have to get a break every 5 hours. In the state of North Carolina, the only people who have to get a break are 14 and 15-year-olds. There are no other break or rest laws in the state of North Carolina. The only people who need a break in North Carolina are 14 and 15-year-olds. That doesn't mean you should work everybody else and never give anybody lunch or breaks. It just means by law, the only people who have to have one are 14 and 15-year-olds. Now, I do want to mention the schools in session, schools out of session. So there were some questions on that, and I actually went to North Carolina Department of Labor and I asked them this question directly, what that means. Does that mean it's spring break, school's out of session, or not? And they said, no, absolutely not. School out of session means the summer. School in session means literally any other time. So your kids off work because it's Christmas, off school because it's Christmas break, you want them to come in the office and work with you, not okay. They still need to follow the same hours as if school is in session. 16 and 17-year-olds, you have a little bit more leeway. And with the permission of the parent and the school, they can actually be treated as adults. They can be treated as 18-year-olds. But without that, when school's in session, they can work a total of 23 hours a week between the hours of 5 a.m. and 11 p.m., sorry. But when school's out of session, so during the summer, they can be treated as an adult. So all those 16, 17-year-old lifeguards that you see out there that probably don't get a break all day, that's totally legal. They can do that all day long. Does anyone have any questions about the child labor laws? Okay. So this is an interesting case that's actually currently still ongoing. It's been going on for almost 19 years at this point. So back in 2000 or before 2000, all the FedEx drivers that you saw were labeled as independent contractors. They were not employees of FedEx. However, FedEx made them wear their uniforms, drive their trucks, use their little scanny things when they're delivering packages, and told them where they needed to go and what needed to happen. They also didn't pay them for the time that it took to load and unload the truck at the beginning and the end of the day. So FedEx was paying them as independent contractors as if they weren't employees, which means they also didn't get any benefits and they didn't have any vesting in the company retirement plan. So way back in 2000, someone said, this does not seem right. I feel like I'm an employee of FedEx. I'm not an independent contractor. And the courts agreed with them. So since 2000, they have been expanding this lawsuit, and it's currently in 40 different states and affects 12,000 employees. They've initially settled it at $240 million to all of these people. However, the reason why it's still an open case is because they haven't looked at the retirement benefits. So all of these people who have already sued and settled now may get more money based on the fact that they didn't have retirement benefits all of this time. So this brings up a point that came up at the beginning. What makes someone an independent contractor versus what makes them an employee? So this one seems pretty easy. Like FedEx was really controlling everything that they were doing. That seems silly that FedEx wasn't considering them employees. But sometimes it's not that cut and dry, and sometimes it's more complicated. And it's more complicated, especially with startups. So a lot of times, startups are told, it's cool, you can hire everyone as an independent contractor until you feel more confident in your income stream, and then you can switch them over to employees. That is terrible advice for multiple reasons. If somebody is going to be if someone's going to be an employee 6 months from now, then they're an employee now. There isn't a magic switch that we flip that says, oh, this person was an independent contractor, but now they're an employee, but they're doing exactly the same job. So the reality is, if you have someone working for you who is substantially contributing to the product or service that you're doing, they're probably your employee. If you have somebody who's doing project-based work for you, is doing something that you don't do as an organization or a company, you don't have this within your organization, this is not something permanent, they might be a contractor. So let's say you make 3D printers and you need to build a website. You don't have your own in-house web designers or IT department that can do that for you, so you go out and you hire someone to do this. You pay them as an independent contractor. Let's say you don't have an employee handbook and you know that your company needs an employee handbook, so you hire someone like me to do that for you. You pay me as an independent contractor. I'm not part of your business. I'm not significantly contributing to your bottom line. I am just doing this project for you on the side and coming in. Now let's say you actually own a web design business and you have a lot of clients and you really can't do all of it on your own, and so you decide to hire an independent contractor to help you with a few of them. That's going to be a lot more difficult for you to sell that that person's an independent contractor versus they are an employee, because they're doing something that is what you are selling as a business. They're doing the core of what your business is. Now, there are definitely a lot of gray areas in this process, but some of the things that you really need to think about when you're thinking about an independent contractor versus an employee is, as an independent contractor, you cannot direct the work that the person is doing. You can give them guidance, you can tell them this is the end result of the project, you can say this is the deadline, but on a day-to-day basis, you cannot tell them what to do. Additionally, in most instances, they need to supply their own equipment. They can't just come in your office and sit down at one of your computer stations and do their work on that. It really needs to be that this person is doing something independent away from your business. And that's how you pay them as an independent contractor. Now, I will tell you that this is one of the things that the government is certainly cracking down on and looking at for one very specific reason: they want their money. So when you have an employee, you're taking payroll taxes out of their paycheck on a regular basis, right? With an independent contractor, they're sending you a bill, you're paying them the money that they ask for, you're not taking any taxes out of that. You're relying on them to pay whatever taxes they're supposed to pay to the government. The government isn't getting those taxes on a regular basis because a lot of times it happens underneath the table. So the government really wants to make sure that the people who are independent contractors are truly independent contractors, and that if you have someone who's doing work for your business on a consistent basis, that you're labeling them as such and you're taking appropriate payroll taxes out. Does anyone have a question or want to be brave and tell me about an example that they are currently dealing with? Yeah.
So what if they are like salary exempt? So
Okay.
if the salary exempt, of course, they can only work 40 hours, and then if they go over that 40 hours, they're not going to get paid for that. So is that part of the FLSA?
Yes, so that is part of FLSA. So part of the Fair Labor Standards Act decides whether someone is an exempt employee or a non-exempt employee. When someone is an exempt employee, it literally means that they are exempt from all the rules of the Fair Labor Standards Act. How much money they're paid, their overtime, all of those things are separate from what we're talking about here. And the overtime is one of the big parts of it. So in order for someone to be an exempt employee, they have to meet certain criteria. They have, in most instances, they need to manage either money or a significant project for the company. There are lots of different reasons why someone can be exempt, and it's more complicated, but there are lots of ways that you can figure it out as well, whether someone should be exempt or non-exempt. Now, the bigger part of that, not just the duties tasks or what they do on a regular basis, is how much money they're making. So I don't know if you guys remember, but a few years ago, Obama was trying to increase the salary threshold for exempt employees. So right now, in order to be considered an exempt employee, you have to make, and I get this wrong, so I write it down, you have to make $23,660. I get it wrong because I think it's so small that it's crazy and my brain just can't process it. So that number has been around for a really long time, right? So when you think exempt employee, you think executive, you think someone who should be making a lot of money, but the reality is under the Fair Labor Standards Act, it says it only has to be $23,666. So a few years ago, Obama said, that is really not in line with what exempt people are making. I want to raise it to $47,000. And it went pretty far, and then it was stopped at the very, very last minute. And there were actually a lot of companies who changed their manager salaries to that $47,000 threshold because it really looked like it was going to happen. I remember specifically because I was in an airport trying to go away for Thanksgiving, and we were about to change 1,000 people's salaries, and we had to stop it at the last minute, which I did from the airport while I was trying to go away for Thanksgiving. But the reality is that went off the table, and then it went back. And it went through committee, and now the Department of Labor has decided that what they have come to is $35,305. So it's sort of a midway point between those two numbers. And they've added in a couple extra things that employers should like. So they're also saying that it's not just about base salary anymore. You can take up to 10% of bonuses and commission into account when you are figuring out, is your exempt employee making $35,305? Which is super handy if you need to somehow make that commission a little bit higher at the end of the year to reach that $35,305. Yes. Okay, oh, we're done. And that brings us to the end of our time.